Good evening.
Good evening.
You are here live with Courtside with Lawman,
And Carmen D.
and we are here to talk about issues related to criminal law, issues that affect the public and the community. This is an informational and an educational program, and we encourage our viewers to participate by posting their comments in the chat or calling in at 916-443-5288 with your questions. And we will answer your questions live on air.
Or, yes, any way you bring it to us, we'll try to answer. And understand that any advice or anything that we talk about is not advice as to your specific case, and we're not giving legal advice as to any specific case. We're talking about crimes and issues in general. So we're an informational and educational program. Now, you ready, Carmen?
I am ready.
All right. Tonight, we chose guns. Gun law, I would say within that would be possession of guns, sales of guns, use of guns, transport of guns, guns in general.
Which seemed to be a very, our society has
A love hate, would
uh,
you say, with guns?
I would say so. I would say so. I mean, we have guns as part of our culture, guns in the movies, um, and I think it causes a lot of young people to be intrigued by the idea of a firearm.
I think it was Tupac. He said in his song, "I'm not mad at you," that he caught a felony because he liked the way a gun blows. Just liking the way a gun blows.
I'm not as familiar with the lyrics of that particular song, but I do know that we see a lot of young people, particularly young men, and I'm talking about in the ages of basically 18 to 30.
Younger, even,
Um,
frankly.
yes,
Yeah,
I don't have handle juvenile cases, so
yeah.
I don't see the people who are under 18, but in the age range of 18 to 30, who are charged with gun possession. Now, to purchase a handgun, you need to be in California at least 21 years old. Now, for some of the long guns that are used for hunting, like rifles, I believe you can possess those uh,
Yeah.
younger than that. And you certainly can be trained uh, on handguns before the age of 21 if you have parents that are
Right.
familiar and put you through the training or even pay for you to attend classes that relate to it. But you cannot actually purchase and own a gun in California if you are under the age of 21.
Can you use a gun in California under the age of 21?
You can. So, for example, let's say your dad owns a handgun and he wants to take you to the range so that he can show you how to fire that weapon. He certainly can do that. That is not a prohibited action at all. It's just that you yourself, being underage, if you're 18, 19, 20, could not walk into a gun store and purchase a gun. Now, a lot of times, what we're seeing, of course, is that people aren't walking into gun stores and purchasing guns because those guns have to be registered with the state, and there's a registry list, the serial number, all of the purchasers' information is input into the system. What we are seeing is guns that are ending up on the street.
Correct. Which are the result of burglaries or just lost, any kind of stolen.
I wouldn't say that all of the guns that are on the street are the result of burglaries or lost and stolen. As we know, who owns who owns the gun manufacturers? You know, who are the people that have the resources to put those guns onto the streets for people to purchase? Yes, there is some amount of them that are the result of someone having stolen them, but there are other guns that are on the street where it's really not clear how they got there. Another thing that we are seeing a lot of now is what is known as the ghost gun. You familiar with the
Oh
ghost
yeah,
gun,
yeah.
lawman?
Well, we have cases. Anybody who's doing gun cases usually you're going to have a ghost gun allegation. Now, you want to explain what that is?
A, a
Yeah,
ghost gun is a gun that does not have a serial number. It's not a gun where the serial number is scratched out. There's actually a separate violation for that. Um, but it is a gun. It is usually a gun that is where the parts are purchased separately, and the purchaser is putting the parts together so that there's no serial number on the gun. And then once he or she has all of the parts, they have a completed gun that doesn't have a serial number that can be traced
so it's not illegal to purchase the parts, but it's the putting it together,
and making it into an
actual
actual
gun,
gun.
operating gun.
Yes.
Because a firearm, the definition of that is a device that propels a bullet through a barrel at a particular target and very fast. I mean, it can be, how they call them zip guns.
Yes. Now, one thing we did talk in one of our other shows about gun enhancements. What we want people to understand is that a gun enhancement can be charged even if the gun was not operable, even if the gun was not loaded. And I
Right.
think the rationale for that is that the
The
victim
victim, right.
on the other side of that firearm has no idea whether or not the gun is loaded, whether or not the gun is operable. But the displaying of that gun puts them in great fear, as it would anyone, for their lives.
Yeah.
Now, we need to look at when we're talking about the ghost guns, instead of punishing young people for these items, perhaps there should be some punishment for the people who are making the money selling these items to young people.
Now, ghost guns. Now, from what I hear, a lot of people go to gun shows, and that's where they can buy these things. I'm gonna guess just
Not here in California, and here in, and
actually
not
no, you can do
no,
it
they
here.
can buy the pieces,
Yeah,
but they
that's what I'm
can't
saying.
buy. They can't go in and buy an
No,
actual
no, no,
ghost
no.
gun
But we're
already
on
put together.
right. But remember, ghost gun only becomes a ghost gun when you put it together.
Hmm.
So I'm saying that gun shows will advertise here's pieces, here's pieces, here's pieces. They can do that. The problem is that when you are to buy or purchase a gun, you need to register it. So in essence, the crime is not that they sell it to someone. The crime is more that when you had it, you then put it together towards operational, and that becomes the crime.
Well, the gun, having the gun itself, having an unregistered gun in California is a crime.
Right. But the ghost guns, if you left it in parts, it would never be a crime. So someone has to try to put it together in order for it to be that ghost gun. So not a lot of people have the skill to do that. Not a lot of people, the workshops to do that.
I wouldn't even actually say, I mean, probably not a lot of people have the skill necessarily to do it 100% correctly.
Right?
So you're going to have ghost guns
May not operate.
that are shoddy, that are put together in a shoddy
Right.
fashion.
It's not like gluing
Um,
pieces together.
but I don't believe that for possession of a firearm that's not registered, I don't know that there's a requirement that the
Oh,
firearm actually be functioning.
well, for well, let me go back because for possession of the firearm, it probably should be operable because you're calling it a firearm, so it has to be able to discharge a bullet. But for the ghost guns, the problem becomes there's components that have to be put together. Sometimes you need to drill, you need to screw things through, you need to do alterations to the parts in order for them to fit together. That's what I mean by the skill to put the gun together.
I would just note that we live in a day and age where anything that someone wants to learn how to do,
You get on the
they
web.
can get on the internet,
Sure.
and there is a video, and there usually are some very good videos in
Yeah.
terms of providing the instructions on how to do these
Right.
things.
See, but it wouldn't. But you gotta put it together to a certain point to make it illegal to possess for the ghost guns.
Yes.
Now they charge them, and they, I mean, you're punished, in a similar way of any gun, illegal gun possession, because the other illegal ways of possessing a gun would be a gun that does not have a serial number that has been scratched off, and that's the gun, and it's not registered to you. A gun that is just not registered to you. If you have possession of that gun, that would be an illegal possession.
Yes. So,
So,
for
and
example,
stolen.
if I had a gun that was registered to me, so it is a legitimate gun, and
Give it to me.
I gave that gun to Keith,
Yeah.
and Keith is walking around with it, it is a gun that is not registered to him, and he
Right.
could technically be charged with a crime. Now, again, we must remember that the district attorneys have discretion, as does law enforcement, in determining who they're actually going to file charges against. If Mr. Staten were stopped with a gun and he said, "This is Miss Butler's gun," and they look it up and they're like, "Yeah, that is registered to Miss Butler," and he's like, "Yeah, she was leaving the office and needed me to
Hold on to
transport the
it.
gun for her, and I'm just taking it over to my office." The officers might decide, "Okay, Mr. Staten, all right, we know you. You've been in this community for 30 plus years. Go ahead and make sure you secure it," and not even bother to arrest him.
Right. Now, that brings up, though, the proper way of transporting a gun, which we'll have to talk about. But you're right. Me just carrying that gun 4 or 5 blocks to my office could be the crime. And the discretion of the prosecution, well, let's say they arrest me and take the gun. Well, if I beat that case, I want my gun back or her gun back.
Well, you wouldn't get it back, but
No,
as the
they'll
registered
release
owner
it.
of the gun,
Yeah,
I could apply for a release of the gun, and the gun should be released back to me,
right.
as long as Lawman hadn't used it in any other crimes.
I didn't. I swear. So that's one way, though. I mean, so now we talked about ghost guns, and now we're moving into the registration part, and so one of the other things, like we were saying, was a scratched off serial number. Okay, even if it's yours, you cannot scratch off the serial numbers, and that makes it an illegal gun now. And then the one big thing is a stolen possession of a gun that's stolen. Now, I got to disagree. There are a lot of guns that are bought on the street. And when they run them later, it turns out there was a burglary 5 years ago, 6 years ago,
Oh, I don't
something like
disagree.
that.
I don't disagree that that
Okay.
happens, but I believe that there are plenty other guns that make it onto the streets from other sources, much like the same way that crack cocaine made its way onto the street from other sources,
Well,
because they're not uh, members of the African American community who are owning gun manufacturers.
but are you saying that manufacturers are putting guns on the street?
I'm not saying that it is directly the manufacturer who is putting the guns on the streets, but the manufacturer is benefiting from the sale of the guns that are on the street.
How?
Uh, any gun that's sold, the profit that they make from that gun goes right into the manufacturer's pocket.
But wouldn't that be dealers who are illegally selling?
Not necessarily,
Then
because
how do I get it from the manufacturer?
number one, we know that there are guns that ended up in foreign countries. How did they get there? Was there not the whole?
I don't know.
Do you not remember the whole? What was it? The with Oliver North.
Oh, well, wait a minute now. You're talking about the Contras selling guns that way.
Yes.
Well, those
And
are
so
U.S.
you
made
believe-
guns, though.
Yeah, we're talking about U.S. manufactured guns.
But I'm thinking about street crime, okay? Here in California or any other state. I mean, I'm not talking about selling guns to the Contras or anything.
No, I'm not. But are you saying that you believe that the government would sell guns to the Contras,
Yes.
but wouldn't infiltrate at any point and put excess guns on the streets here in the United States?
I'm pretty sure they're not putting it in black people's hands. I don't think that the government is doing that necessarily.
It's not the purpose of. So there was a different. I think what you're thinking of is that the purpose for them putting the guns in the hands of the Contras. If you know that those guns are going to be used to eliminate people who are a problem to you anyway,
I
by
got
them
you.
eliminating people in their own neighborhood.
Right.
Is it not possible? I'm sure that there are people who said, oh my goodness, the government never would put crack cocaine in a neighborhood. Why would they do that?
I don't
It
know if we
makes no
said that.
sense. Why would they do that to their own citizens? I didn't say us, but
I
I'm sure
mean,
there are
well,
people
who would respond that way?
who would,
Why
yes.
would that be the government's mission?
So we just never know. It
Yeah.
just seems that the
Well,
street are flush is flush with guns, and I'm just not
yeah.
believing that all of those guns came as the result of a burglary.
Okay. Or well, now not just necessarily burglary, but stolen, or just being bought and sold for years, illegally. That's all. So, but they're all illegal.
We do have some comments in the chat that we need to get to.
Oh yeah.
Here in Michigan, you have to register handguns. You do
Right.
not have to register rifles or shotguns. I believe that that is the same
Same case
standard
here.
here, except for assault rifles here.
Right.
There is a grandfather clause where if you owned an assault rifle prior to them becoming illegal, you had to register those with the state.
Right.
Other than that, assault weapons here are illegal. We have an additional question from Sheepdog Protector. Why is the judge in Kyle Rittenhouse's case not allowing the defense to call people he shot and killed victims?
We were talking about that beforehand, and we want to handle that. Let's handle that last, maybe. Because we were talking about that, and how did that relate to us here, and why the judge would do that there. So yeah, let's save that question. Now, we were talking about illegal guns. Now, let's talk about stolen guns, right? Guns that are stolen. If, in fact, someone sells you a gun and it's stolen, then now you are in possession of an illegal gun. How it got stolen, it would not necessarily be ascribed to you. You see, it might have been a burglary, might have been something, how it did. But because you have it now and it's registered to someone else, not you, and it was stolen, that would be the crime. Now we're and many of these gun illegal.
Let me say
things,
this: you have to know that the gun. You have to have some knowledge, or you knew or should have known that the gun was a stolen gun.
Well,
so a gun
not really,
that
though.
has been you
Because
do in order to be convicted of the crime of possession of a stolen gun.
It's just possession of an illegal weapon.
Well, that's a separate crime.
No, that it would be because the weapon is stolen. It makes it illegal.
You have to know that it's stolen. If
No.
I have it, yes,
No.
yes. If I have it and I have no idea, really, in that instance, what makes it illegal is the fact that you're not the registered owner.
Exactly.
So it doesn't matter whether it's a stolen gun
but,
or it's
that's
a borrowed
what I'm saying.
gun.
But that's what I said
it's the fact that it's
yes,
not registered.
And that's why I said they'll look it up and see it's stolen, but they're not going to charge you with the stealing of the weapon or anything like that.
Unless it was recent.
Right, well, and you were tied to the burglary or whatever it was. It was your parents. I mean, a lot of people take them from their parents and they inherit guns, and that's how they get on the street illegally.
And guns are sometimes also lost. People have them in their, have them on their holster. They go and they, go somewhere. They go to a bar, a restaurant. They forget. Now the gun is lost, left in the bathroom. Somebody finds it, gives it to somebody else, sells it to somebody else.
You mean I can carry a gun in a holster in California?
You cannot.
Okay. So,
let me rephrase that. Unless you have a concealed carry.
Exactly. So that's why you
carry permit in California. You should not be carrying
a gun.
Yes.
Yes. Now back to that whole sales thing. See, I'm not saying they're charging you with the sales. We're talking about just illegal possession. And the reason I want to say it that way is because illegal possession can be a felony or a misdemeanor in many times. So it's what we call the wobbler offense. You can charge it as a felony, you can charge it as a misdemeanor. It is in the prosecution's discretion to do so. If you don't have a record, you don't have a history of anything, doing things wrong, you're not a dangerous person, then it could possibly be a misdemeanor. If you have a prior gun offense, something like that, even if it's a prior misdemeanor, then the next one would probably be a felony. So when it comes to gun possession, you really got to decide one thing. am I going to buy the guns legally from a dealer? Am I going to, once I buy them, register them? And if you do from a dealer, because that's required, you got to register them.
And actually, the dealer assists in the
That's
registration
right.
process. So
They ain't going to give you the
if
gun unless you pass.
if you buy it from a registered dealer,
Right.
the gun is going to be registered, and that is
Right.
the proper way to obtain the firearm.
Right.
That way, you avoid the problem of being charged with illegally possessing a firearm.
Now, the other part of this is the transport, because I can have a legal gun and I'm not transporting it properly. I got it in my car.
Well, what about the locked glove box, Lawman? Does the
Well,
locked glove box count? Can I transport it in my locked glove box?
I'm going to give you the way to transport a gun. First, bullets out. So magazine out. If it's a revolver, bullets out. So the gun cannot be loaded. Then they should be in a locked compartment away from each other. So glove box locked. It could be.
No, no,
Yeah.
no.
You say no?
You cannot. Please do not.
No, wait.
You cannot.
One of the components there.
No,
the other.
You can never
the
have the gun in the. Maybe you can keep the bullets there. You can never have the gun in the glove box. The glove box does not count as a locked container for transporting a gun. Let's be extremely clear on that.
And I'm going to check that code section. But
the glove box does not count. You having it in the glove box will result if there is a legitimate stop and a legitimate reason to search the glove box. If the gun is there, that will not count as a locked container, and that will get you a charge. Do not transport your gun in your glove box.
Then where do you suggest we transport our weapons, Carl?
Well, I thought you were going to tell people where they transport them.
All right.
The glove box is a no-no.
Hold on, I'm going to check on that, though. All right? Because I actually just looked at this.
I am telling you 100% the glove box is a no-no.
All right. But you said I can put my bullets there, right? And all I'm saying is the two things must be away from each other.
But let's be clear. I just really want to emphasize that because I know that to be a fact. You cannot transport your gun in the glove box. And I don't want anyone to think, well, if I have my bullets in my center console and I put my gun in the glove box, it'll be okay. The glove box does not count. I repeat again, does not count as a locked container.
Okay. Now, what would be the proper way to lock it away then? Because would the trunk be a locked container? Can I put it in the trunk?
I believe that you can put it in the trunk, but I believe that the proper way is to have a gun case, a locking gun case, and have the gun locked in the locking gun case and have that inside of the trunk. That is the safest way.
Are the bullets locked in the gun case? Or the magazine?
The magazine can be locked in the gun case if it is, I believe, if it is not loaded.
Now, if you carry, hold on, because we're going to let me check something right quick. Yeah, here we go.
We have a comment here from Sheepdog Protector. And it's again related to the Rittenhouse case. Do you want to save the answer those questions until the end?
Yeah. Let's talk about Kyle later and what's happening in his trial.
So, Sheepdog Protector, we will get to those questions, but we're going to hold that until near the end of the show.
Right. Now, because we're talking about now the carrying of firearms and whether should they be locked and where can they be locked. Because number one, you can get a gun lock that specifically has a cord on it that you can run through if it's a revolver, to run it through the wheel and through the trigger so that gun cannot be loaded. If you have a semi, you can open up the slide and run it through the slide so that the slide can never work.
I'm going to get a resident gun expert on the phone
who's gonna cure this thing. All right, you get your expert on the phone. But here's the thing, though.
So you've got those kinds of gun locks that you can buy. They're just basic locks, master locks, and things like that, but they have a large cable on them. And if you run those through the gun, then the gun can't operate. So you can't load it, you can't fire it, or anything. You can carry that around on your seat if you lock it that way.
I don't believe that to be true.
Yes, all right. Ask our regular gun expert about that one. And the key, though, is the bullets must be separated from the gun. You can lock your gun in the trunk and I believe have the bullets in the car, and you will be okay. Now, now that's transport, because a lot of people transport their guns right to the range. Even if you're going to the range, you can have a gun bag that actually locks, and you can put them in there. The key, and here's the purpose behind this law.
Is this Moran tactical?
The purpose behind this law is so that you cannot reach the gun.
I'm going to have you answer a few questions for our viewers.
You can't use your gun immediately. You have to go through some device in order to have the gun, first of all, access and then load it.
First,
so
now we have our resident gun expert on the line.
All right,
I'm now going to place you on speakerphone, sir, so that our viewers can hear you.
Right.
Are you there, gun expert?
Yes, I am.
All right. The first thing that I want you to clear up as to whether or not I'm right on this or whether or not Lawman is right on this. I have indicated that a person cannot carry their firearm in the glove box, even if it is locked, because that does not qualify as a locked container.
No bullets, unloaded.
I have to give this one to Carmen B. The carriage of a concealable weapon in a vehicle in the state of California, the glove box is specifically stated as not counting as the locked separate container.
Thank you so much.
There is so the requirement for transporting a firearm in a vehicle in the state of California is that it must be in a locked container, not the glove box. The statute specifically says that the glove box, even if it's locked, does not count as the locked container.
Thank you.
No, you may not. Yeah, so you can't keep your gun unloaded or unloaded locked in your glove box of your car.
All right.
The next question is,
he's not going anywhere.
All right.
The next question is Lawman believes that if you have the cable lock on the gun, that you can just have the gun on the seat. Now, I've indicated I don't believe that you can do that, that if you are transporting the gun, it needs to be in a locked container. Can you?
I have to give this one, I'm going to give this one 3/4 credit to Lawman. By statute, that is legit. As long as the gun is in plain view on the passenger seat, locked with a cable lock in such a way that it cannot have a round in the chamber, that is letter of the law, legal. However, I think the spirit of the law, if you should have a law enforcement interaction in that kind of circumstance, you're just unnecessarily raising the probability of that having a negative outcome.
And so I would not suggest to any of our viewers that you drive around with your firearm in that way, especially since we know that it appears that when law enforcement sees brown skin and color, they automatically see gun even when a gun is not present. So why would we suggest that you do something that would put you at greater harm?
I would, like I said, again, it's letter of the law. Like, legally you can do it. I believe it's an extremely inadvisable practice.
Thank you.
May I retort? Okay. Here's the thing. What I'm saying is that I'm not saying carry it around all day, all night. Okay. I'm just saying to transport it from one place to the other, you can do it that way.
But is it an advisable way, considering?
But it's inadvisable.
However, the law does allow.
The law allows a lot of things that we don't suggest that people do because we've seen what the potential outcome.
For example, the law, I mean, I can legally walk down the street with a samurai sword strapped to my back, but that's also guaranteeing that you're going to have a law enforcement interaction every 15 minutes while you're doing it.
And why would they interact with me if it's a legal act?
Because there's going to be someone.
Go ahead. So first of all, so if you got pulled over for another traffic violation and they saw the firearm in your car, one, you're giving them grounds to perform a warrantless search on your car, because if there's a firearm present, then they're going to have to inspect it to make sure that it's not loaded, and then they can inspect it even if you don't give them consent to search your vehicle.
Now, I get that. However, I can still exercise my rights and say, I'm taking the fifth, and they can look at that gun, and when they see that it is locked, then, right?
Counterpoint, they can visually see that it's locked, but I am of the opinion that they would be well within their authority under 12031 and 832 PC to have you exit the vehicle and to physically inspect it directly.
Now, and that could be, I understand that. You see, no, but I'm just saying, if in fact that's all you have is a lock that goes through the gun,
your best bet is still to put that gun inside the trunk to avoid any problems.
Put it in the trunk, or spend the $20 on the hard plastic case so you can have the cable lock through the gun, and then put it in the hard plastic case with a little $5 brass padlock on the outside in the back seat, where there's no way you could realistically reach it while you're in the driving position of the car, and then you've now removed a lot of whatever probable cause that law enforcement could attempt to articulate to perform a warrantless search.
And the best way to do that is have it in the trunk where they can't even see it at all. We do have a question in the chat.
Stay on the line if you can. All right.
We do have a question in the chat from Mark Vaughn. So if you have a permit to carry, it has to be unloaded. No. If you have a permit to carry, it can be loaded. Correct, gun expert?
Correct.
Okay.
Correct. Yeah. If you have a seat now, some concealed weapons permits will place conditions on it, like it can only be in the performance of whatever your work, etc.
Right.
But if you are in a time and a place that your permit covers, then yes, you can have your firearm loaded, and you can have it in your holster. You can have it concealed in the car. You can have it in the center console, etc.
Again, we're talking about people that have the concealed permit.
They have a valid concealed weapons permit. However, it is always advisable, if you have a concealed weapons permit and if you have a law enforcement interaction, to let law enforcement know that you have a permit and that you have your concealed weapon upon your person.
Well, that doesn't always work for certain people.
Philando Castile?
Yes, Philando Castile. That did not work for him. Because we know that Philando Castile informed the officer that he had his registered firearm with him, and the officer still fired and killed him.
I have another question from Moran Tactical.
All right.
Here's another question.
Lawman.
Okay.
If I have both the magazine and the gun in the trunk, should they be separated by a locked device?
Talking about loaded magazines?
Yes, my magazine is loaded, but it's out of the gun, and I lock the gun in a case. Can I keep the magazine in the trunk also?
There is some conflicting case law on that. If the magazine is out of the weapon, but in the same case, there is some case law that says that's compliant with statute. There is some other case law that says that's not in compliant with statute. So I would say that the most advisable course of action would be to have the magazines in a separate container from the container that the firearm is in. If you have loaded magazines not in the firearm, but in the same container as the firearm, and it's locked, that's a gray area. And so I would say that you could probably successfully argue it in court, but it's an inadvisable way to do it.
Okay.
So the advisable way is to have the gun in a locked case, to have any loaded magazines in a separate
container. Yes.
Okay. And does that container also need to be locked?
By statute, no.
Okay.
Right.
We have another question. So I'm going to ask you, our resident gun expert, to remain on the line. We have another question from CC Badger. Hi. So my son has a permit. Gun was removed from the safe by police and taken. Was allegedly charged with domestic violence. Charges were dropped. Why do the police still have his gun? Okay. Now that we don't need. We don't need you for that. We will answer that one. So we'll ask you to stay silent on that one.
Okay. He was arrested for domestic violence. When you are arrested for domestic violence, or even if you have a restraining order that is filed against you for a period of time until that case is resolved, they can have you relinquish your weapons. Now, whether it's in a case, locked, doesn't matter. Any weapons registered to you or that you have. Now, you've told us the charges were dropped. So when the charges are dropped, the police don't know that they have the gun, and they're just not automatically going to go, oh, his charges were dropped. Let me give him his gun back. He has to go to tell the DA involved, release my weapon. And then the police can release the weapon to the registered owner of the gun.
And actually, the DA, when the charges were dropped, the district attorney at that time should have issued a release of any items of property.
But you got to tell him.
So he may.
You got to tell him.
So sometimes you do. Sometimes they do it automatically.
Yeah,
so what he can do is he can contact the property division of the agency that arrested him and request whether or not they have received a release from the district attorney so that he can come and pick up his weapon.
And that'll happen.
If they have not, then he would contact the district attorney's office, ask which district attorney handled his case, and then ask them to file the release. Now that doesn't always work out, and so then the next step is he may need to contact a lawyer to help facilitate the return of his registered weapon.
The lawyer who represented him should have done that at the end of the case.
And he may not have actually had an attorney because she said the charges were dropped. So they may not. Sometimes people are arrested and no charges are ever actually filed, but items are still taken and booked into property. So certainly, if he has an attorney, he wants the attorney to assist him.
Right.
If he didn't have an attorney, then he can contact an attorney. If he contacts the law enforcement agency property division and they're not willing to release it to him. And when it's a domestic violence case, there's always a concern that something may happen if there is a weapon in the home. Now, Lawman had said that if there is a restraining order, so if there is a restraining order, the person will be prohibited from possessing a firearm. And I believe it's not just during the time of the restraining order. I believe it may extend for a 10-year time period.
I think
we have hold on one second. We'll bring you back in. Go ahead, gun expert.
So there's the way that things are supposed to work, and then there's the way things really work. There are many police departments, there are many jurisdictions that are not gun friendly towards private persons owning firearms, and they will throw up as many obstacles as possible, essentially on the theory that most people will not be willing to spend $500, $1,000, $1,500 in attorney fees to to try to get their, if your gun is worth $400 or $500, you're probably not going to spend $1,500 in attorney fees to try to get your gun out of the property room of the police department, or they may just destroy it. And then when you finally show up with your paperwork to try to get your gun back, oops, we destroyed it, so sorry. Knowing that, again, you're probably, not, your only recourse then would be to sue that police department and etc. So, yeah, unfortunately for the person that called in, depending on the jurisdiction and how gun-friendly that jurisdiction is, that gun may just, you'll probably never see it again.
But the only way for them to find out is to contact the agency and find out whether or not they are still in possession of that gun. Now, resident gun expert, I do have a question for you. What happens?
Okay.
What happens, or what is supposed to happen to the guns that are confiscated if they are not returned? Because let's say it's an illegal gun or it's a ghost gun, and so it's confiscated by law enforcement. What is supposed to happen with those guns?
So what is supposed? Well, it's okay. So if a gun is confiscated by law enforcement and it ends up in property, and then either the gun
Ordered to be destroyed or something.
wasn't properly registered, which that happens quite a bit because there's people that purchase guns legally in other states, or they inherited guns, from a father or an uncle, but they didn't go through the process of registering them with DOJ. So the guns are gray area legally owned by the person, but then they get confiscated by law enforcement if they never went through the process of doing the DOJ transfer paperwork. And law enforcement will run the serial numbers of that gun through California DOJ database and say, oops, yep, sorry, you're not, this gun is unregistered. And so if it's a gun that is in a not legal for California configuration, it's supposed to be destroyed. If the gun is in a otherwise legal configuration, but there is no lawful per California regulation owner of it, some agencies will destroy those firearms. Some agencies will sell those firearms, but those firearms are typically sold to national level distributors, and then they are auctioned off in other states.
All right.
So again, that depends. So your larger agencies don't want to deal with any type of potential liability. So, your LA PDs, your San Francisco PDs, your San Jose PDs, they pretty much just anything that's unclaimed or not properly registered, that once it's no longer being held as evidence or potentially going to be needed, to resolve an active criminal case, they have a date with a metal shredder, and they get crushed and melted down. Your smaller agencies like your Bakersfield PDs or your Sonoma County sheriffs, they'll auction those off, or they'll sell those to a firearms distributor, and then they're resold out of state.
Okay, resident gun expert, we have a question from Mark Vaughn. He wants us to ask you whether what size gun magazine are you allowed to have for a pistol or handgun in California?
I think I can answer that one first.
We will let Lawman answer it, and then we will hear from you.
All right.
Okay.
Of course.
So let's go ahead and take a swing, Lawman.
All right. Magazines that fit that gun that hold 16 or less, especially in the Glock, are okay. It's the extended mags that hold approximately 30 or so where it starts to get illegal.
Or 40 or 60.
Yeah,
or
I'm over 30. I'm just saying over 30, then it's starting to get illegal.
Wait.
But, yeah.
Over 30?
30 or over.
So less than 30.
That, if your magazine, I think you can have it.
All right. Let's hear from you, resident gun expert.
All right. So this is a complicated one because there's been several federal lawsuits.
Right.
There's current pending
Right.
federal lawsuits against California's law. So current California law, I'm going to tell you what the law says, and then I'm going to tell you how the current federal court injunctions are affecting that law.
Right.
So current California state law is that you're not supposed to magazine that can hold more than 10 rounds for a pistol or a rifle.
So when Lawman said 16, he was wrong.
He's wrong by black letter statute. Now that law is currently under injunction by the U.S. Federal District Court for San Diego, and is currently awaiting the full en banc of the Ninth Circuit Court of Appeals in San Francisco to make a ruling, which will almost assuredly be appealed by the California Department of Justice, and then probably go to the Supreme Court.
Yeah.
So by black letter statute, you are not supposed to have more than a 10-round magazine. So now the other part of the statute.
So hold on, gun expert. I just want to make sure that our viewer, Mark Vaughn, heard that. So the gun magazine should not have more than 10 rounds.
Now, the second gray area to that, because prior to the outright prohibition of any firearms magazine that holds more than 10 rounds, for the last 15 or so years in California, the rule that was in effect was if you had a magazine that held more than 10 rounds that you had acquired before the prohibition of the sale of those magazines in California, the quote unquote grandfather clause.
Right.
So if you had it wasn't illegal to possess them. It was only illegal for them to be sold, manufactured, or distributed. Right. So gun shops couldn't sell you a 15-round or a 30-round magazine, or you couldn't mail order, technically legally, a 15 or a 30-round magazine. But if you happen to have one, like, oh, hey, where did this come from? Look what I found in the bottom of my gun bag, a 15-round magazine. Then that was legal. And so that is the current regime that is in place. It is not illegal because the California statute is currently being enjoined by the Federal District Court for San Diego. So that's why it is legal if you are a private person who is not otherwise prohibited, you can own a 15 or 30-round magazine.
Are you 100?
Let him finish, Carl.
Are you 100? Because I don't want to give misinformation. Are you 100% sure about that, sir? Are you 100% sure about that?
Yes. The litigation, right?
I'm 94.
Yeah, see, 94 point whatever is not sufficient because we don't want people following that if it is inaccurate. And I believe that even though initially it was enjoined, there were other filings. And so I believe that the law still stands that it is at the number of 10.
No, that is not. He is right. No, that is not true. I'm serious. I saw this one. See,
Did you?
Yes.
And I would point out, Lawman and Carmen B, that the fact that the three of us with our combined 27 college degrees and combined 100 years of legal experience are this confused on it.
Imagine.
There's no way that the private citizen, without our 100 years of legal training, could realistically be able to interpret these laws, which would, on its face, support the opinion of Judge Benavides in San Diego that California's gun laws are so arbitrary and complex and capricious that they prima facie violate the Second Amendment rights of law-abiding California citizens.
And they're claiming that they should be rewritten, over again for these days and times because there are a lot of 30 mags, 20 mags out there that are being used. But right now, if you have that, you can have it until that decision is made. So, all right. Oh, we're getting near the end. And so I want to bring up the Kyle Rittenhouse situation. So we want to
thank you, our resident gun expert.
Thank you so much. All right. Now, so we talked a lot about guns, right? So if you have questions, I think you can go to dealers and ask them about can you buy a certain gun or this and that, okay? But we're going to turn now my attention to the Kyle Rittenhouse trial that's going on. One of the motions in limine, a pretrial motion in the trial, was to not call the individuals who were shot victims. Now, in California, we have that battle here all the time. If I'm defending someone, I don't want to call the person known as a victim because they haven't become a victim until the case is over and it's been ruled that they are the victim of a crime. So the argument is, don't call them victims until they have been true victims of crime because a person has been convicted of that offense. But there are motions that we will make here in California that no, don't call them victim at any point right now. Now, here's the thing. We are not in California. Because if you're in California, more than likely the judge is going to allow them to call them that. It is not necessarily fair, but you've got to make that record for appeal that you should not call them victim until and if a person is convicted. Here, the judge ruled in what I would say is probably going to be improper on appeal. Okay, I think he'll be overruled because I think he rationalized that, well, are these people engaging in illegal conduct? Are they doing something whereby they are not, following the law or doing something anti the law, and therefore we won't call them victims? You see, I think he is wrong in that ruling, 100%. Not that I want everybody to be called victim, but you should always give the prosecutor the leeway of calling them victims because at the particular point in time right now, that's how the prosecution's view is. And the jury would be admonished that, calling them victim doesn't mean that the crime has occurred. You see, you can ask for that instruction. But I think they're wrong for doing that. The judge is wrong for making that decision in this trial. You want to read a paragraph? Yeah.
What I think is interesting is that while he is saying that they can refer to the alleged victim as a complaining witness or the decedent, he does say that the defense attorneys can refer to those alleged victims as arsonists,
Right,
as looters, as rioters, as long as there is evidence that they took place in those sorts of activities. So to me, it shows that we have a judge here who is probably not impartial.
Not biased. He is biased.
He is clearly biased.
Right.
Because it would have made more sense for him to say, well, the prosecution refer to them as the victim, but then I'm going to allow to the defense looters.
Right.
And so you would have both opposing hands of the prosecution. Now, what I would be interested, how many times has he made a similar decision when the defendant, case, the person seated in that chair accused of murder, was a person who was African American?
But here's the thing, not even of color, but there's a self-defense issue. There's some issue, you see, to the assault that I did it, because this person's in my house, trying to break my house. I didn't like what they did to me. They assaulted me, things like that. Now, notice what he's doing is he's trying to split the baby here. He's trying to say, oh, well, you can call them victims, but these people were doing wrong too.
No, because I thought, and correct me if I'm wrong, I thought he was precluding the prosecution from referring to them as victims. So he is clearly not splitting the baby.
No.
He is saying, I'm going to allow the defense to denigrate these individuals, but I am not going to allow the prosecution to refer to them as victims. He's saying it is up to the jury to decide whether or not they're victims. And I just find that to be
here's
unusual.
Where that's fundamentally wrong, because they are not on trial for arson or looting are rioting. They are not on trial for that.
They are not on trial, period, because
No,
they
but-
are the. They are.
But here's the thing. What I'm saying is, in this trial, they're not to determine whether they are those things. You see, that's not instruction. Say, well, you got to find that they're arsonists, or they're looters, or they're rioters, right? It's not a finding by the jury. It's the judge saying you can just call them that. Now, similarly, if I was in that situation and I wanted to call the victims a name and say that they're burglars, they're attackers, they're gang members, they're evil people, I can do that. I can call them whatever I want. I don't need the judge to step in and say what I need to call them. Now, I thought he was saying that if you're going to try to call them alleged victims, then the defense can call these people that. And that's how he's sort of splitting a baby there. So I'll tell you this, though, that trial should be watched by everybody, because you obviously, from the judge's moves in the motions in limine, he's trying to he is trying to denigrate the alleged victims. This is similar to in rape cases before the rape shield statutes that, well, she looked like a hoe, she was dressed that way, she was very come on, she was drunk and came on to me, therefore it's okay for me to rape her. You see, and we solved that problem with the law. This is getting very, very close to that, because if a gang member shoots another gang member, do you obviously the defense is going to say, well, that person's a gang member, they're a bad person, and if they had crimes against them, I'm going to bring it out. So you can do that to people who are alleged victims. You can dirty them up. Where we saw this happen somewhat is in the Stephon Clark case. We saw the prosecutor come out and give justifications as to his character and what he was doing.
Well, that's because they never saw Stephon Clark as a victim. We saw him as
a victim, right?
And he was a victim of excessive force by law enforcement.
But the prosecution is saying, even before the trial, look at who this is. This is not a good person. And just yesterday he committed violence. You see, he's out here now.
Who are you talking about?
The DA, when she came out to give her explanation
as
to why,
because she was saying there was no trial.
Right.
She said, I'm not filing charges against these officers.
But she was putting him on trial. She literally was doing a trial there, because I was on TV commenting. I said, what a great closing argument she just made, for the defense side, because she is doing exactly what I would do if in a self-defense case or a wrongful shooting case, is say, well, that person was violent. That person was this. They yelled at me. They did this. I knew that before I encountered them. So I was ready for them. So the law, what's happening now is the law is bouncing back and forth. We're going back and forth.
What do you mean by the law is bouncing back and forth?
Well, it used to be if you were a victim or something like that, if you were on that side, it was clear and everybody understood, well, that's a victim. And the courts were going, hey, you don't denigrate the victim, similar to a rape shield. You can't say this person is bad because of this. And it's up to the judge to keep it out.
You can't just say that they're a bad person, but if there are things that are relevant specifically to the self-defense,
character
such as
evidence.
This is a person who threatened me before.
Right.
This is a person who is known to carry a gun.
Right.
This is a person who is known to have committed violence before.
You can say that.
Violence.
You can bring that in.
Can be brought
right.
in.
But you can't say this is just a bad person. You can bring those in because the self-defense laws, 505 of Cal Crim. Please, 505 Cal Crim, CALCRIM. It'll pull you up. That is the self-defense law. You can take those things in consideration before you act in self-defense. There is a stand your ground aspect of 505. You do not have to retreat from someone. And you can actually chase them until the danger is gone. So,
I don't like how you phrase that. I want it to be clear.
Chase them.
They have to be posing a danger to you.
And you can pursue until the danger is gone. That's all I'm saying, because that's in the statute. Okay? That's in the law. Please go out, read that something.
But what my concern is that sometimes what people hear is I can pursue somebody and the person may no longer be posing a danger at all, and that person thinks that they can still do something to that person.
But I did not say those things.
I understand, but I like for it to be very clear for the people, because sometimes
I want them to go read the statute and be clear on what the statute says, because I'm just saying if the danger is persisting, you see, and you need to stop the person, even though you have to pursue to do so, the law can allow that. Okay. So watch this case, Kyle's. Watch it very carefully, because I believe what you're going to see is, well, these people were doing wrong. Therefore, he had some right to kill. But the problem is, were they doing wrong to him?
And not just doing wrong, because you could be doing some wrong. It still doesn't give somebody the right to kill you.
That's right.
So right now, I could reach in Keith's pocket and steal his wallet. Right? Would that give him the right to kill me? No, it would not.
Right.
Because I am not threatening physical harm to him or to one of his family members who is present.
Right.
So if someone can be doing wrong, does not give the right to someone else to take that person's life.
So take an example. Because I am rioting doesn't mean you as a private citizen get to shoot me. Because I may be looting a store, stealing does not give you the right to shoot me. If I'm setting fire to something, doesn't give you the right as a citizen to shoot me. It is force that is beyond what should be given, and you don't have the right to stop me. You are not law enforcement unless I am attacking you. Am I setting your house on fire? Am I looting you? Then there may be some force you can use, but still not deadly force against property.
If there is not deadly force threatened, and there is not only a self-defense of yourself, but there is defense of others. We do have a comment in the chat that says assassination of character is hard to clear up. Rest in peace, Stephon Clark.
Exactly. I mean, and that's basically what she was doing. But that's what a defense attorney would do to someone in the trial. And we say assassinate, and that's, I mean, yeah. What you're doing is bringing out the things that made me believe I needed to act. That's it. All right. Let's see. Oh, we're over time, Karen.
Yes. So it is. We are at the end of another show. This has been a very spirited show. We would thank all of our viewers. We appreciate your comments and your questions. Zimbabwe Walker, Moran Tactical, CC Badger.
Yes.
Sheepdog Protector, Mark Vaughn. We appreciate you. We will be here again next Friday, same time, same place, 6 p.m. Again, we invite you to call in or to post your comments in the chat.
Yes. Maybe next time what we can talk a little bit about is what's going on in the Rittenhouse case.
Because it will have proceeded,
hopefully
progressed further.
Right. And there are other issues out there, like the qualified immunity being broken down in certain jurisdictions.
Yes. And I will say there were a number of videos that were sent to us by our viewers this week that we did not get to discuss, but do know that we did view those videos, and we had very spirited discussions ourselves about those videos, and we appreciate them. Please keep those videos coming. I'll just, even though we won't get to discuss them, one was the officers who had tased a man and killed him. And they were actually prosecuted for it, but it looks like it resulted in a mistrial.
I've seen a lot of articles where children are now committing racist acts against black children. Well, white children are committing racist acts against black children in middle and elementary schools, like putting one of their classmates up for sale on Craigslist as a slave.
Another one video sent by one of our viewers was the woman intervening in a wrongful arrest. It was an African-American man who apparently had been attacked by some white men. She actually had seen the entire incident, but when the police came, they just tended to believe that the African-American person was at fault, let the other individuals go, and she spoke up for him, and it resulted in him being released and not unlawfully arrested, which likely would have happened had she not spoken up. So
Right.
please keep your videos and your comments coming. We greatly appreciate those.
Yes.
We thank you again for spending your evening this Friday with Courtside, and we'd like to see you again next weekend.
That's right. And tell us what you want to hear, what you want us to talk about too.
Yes.
So we're going to bid you adieu. I am Lawman. This is
Carmen B.
and we are out tonight.
Thank you. Be safe.
Yes.